Well, hello everybody, and welcome back to Buckle Up, it's the Law with Attorney Larry Forman. Folks, today we are going to cover a fascinating topic. Today we are going to cover the top 10 legal cases that have changed history. Don't forget to like this video, comment below, subscribe to the channel, as always. This is a list of 10 legal cases from around the world, mostly from the United States, that have significantly shaped history, law, and society due to their groundbreaking decisions, controversial outcomes, or notable errors. Let's start with the first one, Marbury versus Madison. Now, what happened in that case? William Marbury sued Secretary of State James Madison. Now, what happened in Marbury versus Madison? It's an 1803 case from the United States about 220 years ago. William Marbury sued the Secretary of State James Madison to compel the delivery of his judicial commission. He was about to become judge. Now, it was withheld under President Jefferson's orders. The U.S. Supreme Court at the time, led by Chief Justice John Marshall, ruled that the law Marbury sued under was unconstitutional, establishing the principle of judicial review, something we never had in the United States up until that point in the 30 years of its existence. Now, the case is significant because it suddenly gave the United States Supreme Court power to strike down laws as unconstitutional, the power that they use to this day, fundamentally shaping the balance of powers in the U.S. government and is a cornerstone of constitutional law. Jefferson's administration tried to block Federalist appointments, but the court turned a minor administrative dispute that had nothing really to do with anything into a landmark precedent that has shaped our country's history. Next is Dred Scott versus Sanford, again in the United States from 1857. Dred Scott was a slave. He sued for his freedom. He argued that living in the free territories made him free. And the United States Supreme Court ruled in a 7-2 decision that African Americans were not U.S. citizens and therefore could not sue in federal court. Congress could not ban slavery in those territories. Now, the decision truly inflamed tensions over slavery between the North and the South back in those days. As you all know, the Civil War very quickly followed a couple years later, and that contributed to the Civil War's beginning. It was overturned by the 14th Amendment under President Lincoln, but remains a stark example of judicial failure to uphold human rights. We also see it again about 90 years later with the Japanese internment camps during World War II. Now, the shocking part about this case was the court's blatant denial of citizenship to an entire racial group. It's just a moral and legal catastrophe, and it was widely criticized at the time. Next up, also in the United States, we have Plessy versus Ferguson from 1896, just 120 years ago. Homer Plessy was a mixed-race man, and he challenged Louisiana's segregation laws by sitting in a whites-only train car. This is before Rosa Parks. The Supreme Court upheld the quote-unquote separate but equal doctrine, legitimizing racial segregation. Now, it was significant at the time because remember, this is the end of the 19th century. The ruling entrenched the Jim Crow laws at the time, which enabled decades of systemic racism until it was eventually overturned about 60 years later by Brown versus Board of Education in 1954. Now, that shaped race relations in the U.S. profoundly. In modern days, it is known as DEI, the Diversity, Equity, and Inclusion laws, and has been disguised as a remnant from Jim Crow laws and affirmative action. So for those of you who think DEI is a good thing, now you know the truth. Now, why it's shocking? The court's acceptance of separate but equal actually completely ignored the reality of unequal treatment, codifying discrimination under the guise of fairness, which made it completely unfair. Now we finally get to step outside the United States, and we're going to the United Kingdom in 1932, just shy of 100 years ago. Donahue versus Stevenson. Mae Donahue fell ill after drinking ginger beer containing a decomposed snail. Ugh. That sounds disgusting. She sued the manufacturer despite not having any contract with them. Now, in England, the House of Lords ruled that manufacturers owe a duty of care to consumers, establishing the modern law of negligence. Now, it was significant because the case laid the foundation for consumer protection laws worldwide, influencing tort law in countless jurisdictions, including the United States, and especially in famous cases like the one ruled by Judge Learned Hand here in the United States. Now, the blunder was the manufacturer's negligence, but the case's shock factor actually comes from the bizarre premise, a snail in a bottle, which led to a consumer protection revolution. And of course, we alluded to this case just moments ago, but we got to talk about it separately. Brown versus Board of Education, 1954, back in the United States. This case consolidated cases challenging the racial segregation in public schools. The Supreme Court unanimously ruled that separate but equal schools were unconstitutional and violated the 14th Amendment's Equal Protection Clause. This decision dismantled legal segregation in schools, kickstarting the U.S. Civil Rights Movement, and of course, overturning Plessy versus Ferguson, which we covered just a few moments ago. This was a decades-long acceptance of segregation. The court's reversal exposed the moral failure of the prior Supreme Court and faced fierce resistance from segregationists. And as I've already alluded to today it still exists in modern disguised format known as DEI. Do you need a lawyer that defense counsel fear? Hire me, Larry Forman. I'm a trial lawyer. I know how to get money in your pocket. If you've been injured in any way, shape, or form, car accident, dog bite, slip and fall, medical malpractice, doctor negligence, hospital negligence, whatever it may be, give us a call. 1-844-774-HURT. That's 1-844-774-HURT. Let's get you some money. Now, we're still in the United States. 1961, Mapp versus Ohio. Police illegally searched Dolly Mapp's home without a valid warrant and found obscene materials, leading to her conviction. The Supreme Court ruled that the evidence was obtained through illegal searches and therefore inadmissible, applying the Fourth Amendment's exclusionary rule to the state courts. Now, the case strengthened protections against unlawful searches in violation of the Fourth Amendment, reshaping criminal procedure and police conduct. Now, for those of you who are longtime followers of the channel, you know that the Fourth Amendment has been slowly chipped away at and eroded by many different decisions since, but the essence of the Fourth Amendment, for what it's worth, still maintains in criminal courts to this day. Now, the police flagrantly violated Mapp's rights, waiving a fake warrant which revealed systematic abuses. So you see, abuse of police discretion and police power is nothing new. And that's what happened in that case 65 years ago. The court's ruling was bold and was a correction of law enforcement overreach. Now we're back to the United Kingdom, 1893. This is Carlisle versus Carbolic Smokeball Company. The Carbolic Smokeball Company advertised that their product could prevent influenza, promising £100 to anyone who used it and still got sick. Well, guess what? Louisa Carlisle sued when the company refused to pay after she fell ill after using the product. And the Court of Appeals ruled that, hey, the advertisement, honey, is a binding contract and inescapable for the company. This case defined key principles of contract law: offer and acceptance. Both parties gave something up, and both parties benefited in some way. The company got the money, and the consumer got the product. And when the product failed, then they must have been paid. Even though the company declined to pay at the time, they were forced to pay by the courts. The company's audacious claim and refusal to honor their promise was a marketing blunder exposed by a determined plaintiff, turning a quirky ad into legal history. So truth in advertising, I know, is a foreign concept, but now companies know if they're going to make a promise, they better live up to it. Otherwise, they're going to have to pay the price. Now we're going to the other complete side of the world, to India. In 1985, and I hope I'm pronouncing this correctly, Shah Bano Begum case. Shah Bano, a divorced Muslim woman, sued for alimony, and the Supreme Court of India granted her maintenance under secular law. But the ruling sparked protests from the Islamic groups, claiming it violated Sharia law. The government passed a law diluting the decision, This case highlighted tensions between secular and religious laws in India, fueling debates about a uniform civil code and just women's rights in general. Now, why it's shocking is that the court's progressive ruling was undermined by political capitulation, a blunder that set back gender equality and exposed legal inconsistencies in India's legal system. Absolutely insane case. Number 9, Al-Khatib versus Godwin. This is Australia just 20 years ago in 2004. Ahmed Al-Khatib, a stateless Palestinian, was detained indefinitely after his visa application was rejected. The High Court of Australia ruled that indefinite detention of stateless persons was lawful, and so he could not be deported. This controversial decision raised global concerns about human rights and immigration detention policies, prompting legal and ethical debates. The court's literal interpretation allowed indefinite detention without crime. That's a legal blunder that shocked human rights advocates for its lack of compassion. Think about it. A man being detained without any ability to be released or to be deported. I can't think of anything more barbaric than that. And last but not least, the Minonette case, Dudley v. Stevens in 1884. Now, this is one of those cases that law students learn in their first week of law school, and this comes from 1884 in the United Kingdom. There was a shipwreck, and 2 sailors, Tom Dudley and Edwin Stevens, killed and consumed a cabin boy in order to survive. They were later convicted of murder, and the court rejected their defense of necessity, ruling that all life is equal under the law. You see, what happened in that case is that both Dudley and Stevens argued that if they had not consumed their cabin boy, they would have both died of starvation. And the court said no. That is still murder under the law. It set the precedent that no murder is ever justified, unless, of course, acting in self-defense or maybe extreme emotional disturbance in some extreme situations. But that influenced criminal law and ethical discussions about survival. The shocking thing about this case is that the gruesome act and the court's refusal to excuse it, despite the extreme circumstances, shocked Victorian society and sparked debate about morality versus the law. It is a chilling tale of survival, cannibalism, and a courtroom drama that questioned human instincts. So folks, I hope you all learned something. As always, this is one of the most fascinating videos that I have made in a very long time, talking about some significant landmark decisions that have influenced human rights and activism cases over the years. I love every single one of you, and I hope to see you in the next video. Bye, everybody.